Good evening. I want to thank you for giving me the opportunity on behalf of the Board of Education to come before you and to provide this general overview and explanation about how negotiations work, mediation, and arbitration. I believe that there are copies of materials that I had previously provided at the Board of Ed meeting, so that provides a lot more detail than what I'm going to go through this evening, because I'm going to hopefully keep my remarks a lot shorter than I did before the Board of Ed. The contract negotiation process is all governed by state law. There are strict statutory timelines imposed and regulated by the state statute. And the state statute is called the Teacher Negotiation Act, better known as the TNA, people who deal with this regularly. And there's a process of negotiations, mediation, and arbitration, and I'll talk about each one. I'll spare you all of the rigorous timelines and the way that the statute reads in terms of when things need to be done prior to budget submission dates, but let me talk a little bit about how the negotiation process gets started. For purposes of how the state calculates it, the negotiation timeline starts for our purposes on June 13th, 2010. And that's all calculated based on the budget submission date, as I had mentioned before. Parties are required to meet in good faith in an attempt to reach an agreement on a successor contract. Neither side is required to make any concessions. And a critical thing to keep in mind is that negotiations are treated very differently under the Freedom of Information Act than many other things. They're called non-meetings. So the public is not invited. They don't have to be posted. There are no minutes kept that get posted, all of those types of things. So they're a clear exclusion to the Freedom of Information Act. What happens if the parties negotiate and actually reach an agreement, which happens quite often? The agreement gets ratified and signed by both parties. A copy of that agreement, and what I mean by ratified, is voted on by the teachers, voted on by the Board of Education. Once it's agreed upon, it gets filed with the town clerk and the commissioner of the Department of Education. And that agreement is binding unless the legislative body of the town, in this case the town council, takes up the issue and actually votes to reject the contract within 30 days of it being filed with the town clerk. So you have to act and vote in that 30-day period. There's no requirement in the law for the contract to be approved by the town council. There's also an opportunity for the public to petition a negotiated agreement to referendum to reject the award, to reject the negotiated agreement. That requires 15% of the registered voters to vote, and a majority of those to vote to reject the contract. But again, I can't emphasize enough, because I'll talk about some other processes in a second, that what I just explained is if the parties negotiate an agreement. So anything other than a negotiated agreement, the process for rejecting that and approving that is different. So, what happens if the parties don't successfully negotiate a contract? There's a 50-day window period of time from June 13th, and that is until August 2nd. And August 2nd triggers what's called mediation. Mediation is, for those people who may not be aware of it, it's a confidential process where a neutral third party is asked to facilitate and help the parties try to reach a mutual agreement. They have no stake in whether there's an agreement reached. There's no record kept of the proceedings. They don't make any type of a report back to the state or otherwise about the positions that the parties took. Their primary purpose is to try to help the parties themselves come to an agreement. Mediation runs for 25 days, begins August 2nd, so it ends August 27th. The parties traditionally negotiate throughout the mediation period. So in reality, the contract negotiation window runs, in our case, from June 13th until August 27th. Up until August 27th, the parties can negotiate an agreement, and the approval process or rejection process applies for what I said before. But if no agreement is reached by August 27th, following at least one mandatory mediation session, the parties go to what's called final and binding interest arbitration. Interest arbitration starts, as I said, August 27th, and And there are some calendar type issues that I'll spare you the details of, but I will get into a few of the details about when there are particular triggering points. Let me tell you first what is arbitration. It's called final and binding interest arbitration. It's also known as last best offer or issue by issue arbitration. What does that mean? What that means is each of the respective parties submit an offer on a disputed issue, wages, insurance, pick your favorite topic. The arbitrators are required to choose one or the other party's offer. They're not allowed by law to choose a midpoint. They're not allowed by law to come up with a different solution that they think is more appropriate than what the two parties have presented as their final last best offers. So they're required to choose one or the other. It's usually a